Welcome to Talk Trials.
It's excellent to be back with you.
If you are joining us for the first time, or if you are a long-time listener, well, you know exactly what we do here. This is the place where we take the sometimes dusty, sometimes really dense, but always critical world of Federal Circuit Court of Appeals opinions, and we crack them open.
We really do.
We don't just read the headlines, we look at the mechanics, we treat the law like the complex living engine that it is.
We'll look under the hood. I like that analogy. We want to understand not just what the court decided, but, how they got there. And maybe more importantly, what that journey tells us about the legal system itself.
We're looking for the signal in the noise.
Exactly.
And usually we're looking at these massive precedent-setting intellectual property battles, the Apple versus Samsungs of the world.
Or those huge international trade disputes.
Right, the ones that span hundreds of pages of briefing and involve, billions of dollars. But today, we're doing something a little different.
We are.
We're unpacking a specific legal interaction, that is. It's short, it's sharp, and it's surprisingly revealing.
It is a look at the other side of the docket, the side where cases end not with a bang, but with a handshake, or at least, the procedural equivalent of one.
So today we are diving deep into the case of Linda L. Hoppe v. Douglas A. Collins, Secretary of Veterans Affairs. And for those of you keeping score at home, this is case number 2025-1836.
An appeal originating from the United States Court of Appeals for Veterans Claims.
And the headline here, sort of the snapshot summary before we really get our hands dirty, is that the Federal Circuit has issued an order.
Just an order, not a full-blown opinion.
And that order is a dismissal, case closed.
Specifically, and this is the key part, a dismissal based on the agreement of the parties.
And right off the bat, I have to point out the classification here. You see it at the top of the document. This is marked as non-precedential. Now, to the uninitiated, that might sound like unimportant, like move along, nothing to see here, just some paperwork. But you and I know that is definitely not the case.
Not at all. In the ecosystem of the Federal Circuit, even the quiet orders tell a story.
So what does non-precedential actually mean in this context?
It simply means it doesn't set a binding rule for every future case. It's not going to rewrite the textbook or change the interpretation of a statute for the entire country.
Okay.
But for Linda L. Hoppe and for the Secretary of Veterans Affairs, this is the entire ballgame. It is the definitive resolution to their specific legal conflict. For them, it is the end of a very long road. And
it offers us this really clear, unobstructed view of how procedural resolution works when the parties decide to take the wheel themselves.
Right.
It's a masterclass in the art of the exit strategy. So are you ready to unpack this?
I am ready. Let's get into the details.
Okay, let's set the stage with the parties in the forum.
Yeah.
This is crucial context because, as we always say, the Federal Circuit isn't just any court.
No, it's a very specific kind of place.
So we have our appellant, Linda L. Hoppe. She is the claimant. And on the other side, the appellee, Douglas A. Collins, who is the Secretary of Veterans Affairs.
And this is a classic matchup in this specific arena. You have an individual veteran, or in some cases, their survivor, the claimant, going up against the massive administrative machinery of the VA.
Right.
The secretary is the named party, but he's really just representing the agency. It is effectively the individual citizen versus the federal government.
A real David and Goliath situation, in a sense.
In many ways, yes. The resources are certainly not balanced.
And this case didn't just appear at the Federal Circuit out of thin air. It rarely does.
Yeah.
This has a history.
Right.
The Federal Circuit is an appellate court, which means they are reviewing something that happened before somewhere else.
Right. This case originated in the lower court, specifically the United States Court of Appeals for Veterans Claims. You'll often hear it called the CAVC.
The CAVC.
Exactly. And we even have the lower court case number. It was 24-1685.
And we also have a name attached to that lower court proceeding, Judge Grant Jaquith.
Judge Jaquith. So let's trace the path here because it's important. Mrs. Hoppe had her case before Judge Jaquith at the CAVC. That court, the Veterans Court, is a specialized Article I court.
Okay, what does that mean, Article I court?
It means it was created by Congress under Article I of the Constitution, not Article III, which establishes the Supreme Court and the federal judiciary. So the judges don't have lifetime tenure. It's a court with a very, very specific mission.
And that mission is?
It only hears veterans benefits cases. That's it. So Judge Jaquith is an expert in this area of law. He made a decision in case 24-1685.
And whatever happened there, whether Ms. Hoppe won on some points and lost on others, or maybe she lost entirely, or perhaps just got a result she wasn't satisfied with, it led to an appeal.
An appeal to the United States Court of Appeals for the Federal Circuit. And that is the forum we are sitting in today, figuratively speaking.
And that is a significant jump. I mean, going from the CAVC to the Federal Circuit?
Oh, it's a huge leap. The Federal Circuit is one step below the Supreme Court. It is a very serious room to be in. It's an Article III court, which means the judges are appointed for life by the president.
It's interesting because the Federal Circuit is so unique in the U.S. judicial system. Most appeals courts are geographical, right? The Ninth Circuit covers the West Coast.
The First Circuit covers New England, and so on.
But the Federal Circuit is based on subject matter.
It is. The Federal Circuit has exclusive national jurisdiction over a bunch of things. Patent appeals are the big one everyone knows about.
Right, that's their bread and butter.
International trade, government contracts, and crucially for us, appeals from the Veterans Court. It is the gatekeeper for legal questions regarding veterans' benefits, statutes, and regulations.
So getting a docket number here, 2025-1836, means the legal machinery has escalated to a very high level.
It really has. Ms. Hoppe has taken this all the way to Washington, D.C., to what is effectively the second highest court in the land for her issue.
And then we get the dates. This is where it gets interesting to me, where we start to see the specific texture of this case. The order date is December 18th, 2025.
A date that will stand as the final punctuation mark on this entire dispute.
But it's not just the order date. The mandate was also issued on December 18th, 2025.
The same day.
Immediate effect.
That is crucial, and we will definitely circle back to why that matters in a moment. Usually there is a delay. There's a waiting period between an order and the mandate to allow for things like rehearing petitions.
But not here.
But here, strictly speaking, everything happened on that one day. The court spoke, the mandate issued, and the case just ended.
So let's talk about the how, the mechanism of this dismissal. The order cites a very specific rule, FedRAP P 42B.
Federal Rule of Appellate Procedure 42B.
Okay, let's unpack this. I mean, we see these rule citations all the time and our eyes can just glaze over.
Sure.
But this rule is the engine of the entire document. What is Rule 42B?
Rule 42B is the escape hatch. It's the off-ramp for appeals. It's the provision in the federal rules that governs voluntary dismissal in the Court of Appeals.
Voluntary dismissal, so it's not the court kicking them out.
No, not at all. It's the parties asking to leave.
Essentially, the rule says that if the parties agree to dismiss the case and they file a signed dismissal agreement specifying how costs are to be paid, the clerk of the court must enter the dismissal.
So it's not the judges sitting down, hearing arguments, reading briefs, and deciding a winner and loser.
Not on the merits of the appeal, no.
It's the judges, or I guess the clerk, acting for the court, saying, if you two are done fighting, then we're done too.
Precisely. It shifts the power from the bench back to the parties. And the key phrase in the specific order, the magic words are, the parties having so agreed.
The parties having so agreed. That sounds so polite, doesn't it? It sounds like they just decided to shake hands and walk away.
It does, but it implies a tremendous amount of work behind the scenes. Think about what that phrase really signifies.
It means the appellant, Mrs. Hoppe, and the appellee, Secretary Collins, through his government lawyers, reached a meeting of the minds.
So a settlement, is that what we're talking about?
Most likely, yes. Or a joint stipulation to dismiss, which is functionally the same thing. In the context of veterans law, this holds a very specific weight.
How so?
Well, when a veteran appeals to the Federal Circuit, they're usually arguing that the lower court, the CAVC, made a legal error. They're saying the judge got the law wrong.
And the government's job is to defend that decision.
The government defends the lower court's decision. So for them to suddenly agree to dismiss the case, something had to give. One side had to move.
Walk us through what that might look like. If I'm Ms. Hoppe, why do I agree to dismiss my case after coming all this way, after all this effort?
Well, often this happens when the government takes a second look at the case. Remember, a new set of lawyers from the Department of Justice is handling the appeal, not the same people from the VA.
A fresh set of eyes.
Exactly. And that DOJ attorney might review the file and see that, you know what, maybe the Veterans Court did miss a key piece of evidence, or maybe they applied the wrong regulation. And instead of fighting it out in a written opinion, which takes months and risks a bad precedent for the government,
They offer a deal.
they offer a deal. It's a pragmatic decision.
And what would that deal look like? A check?
Not usually, not at this level. The Federal Circuit can't award benefits. The deal is usually procedural. They might say, Ms. Hoppe, if you agree to dismiss this appeal, we will agree to a joint motion for remand. We will send this case back down to the agency level and we'll agree that they need to look at it again, maybe with specific instructions.
So you don't win the war, but you win a crucial battle and get to fight again on better ground.
That's a perfect way to put it. The veteran accepts that offer. Instead of fighting for a win in court that might not even get them their benefits directly, they take the win in the negotiation. They get another shot.
And that explains the voluntary nature of it all. It's not a surrender. It's the strategic withdrawal because the immediate goal, getting another look, has been achieved somewhere else.
Correct. Or, conversely, the veteran's lawyer might realize the appeal is weaker than they thought and agree to withdraw to save costs or focus on a different claim. But that phrase, the parties having so agreed, it really suggests mutuality.
It negates the need for any further judicial intervention.
No oral argument. No panel of 3 judges deliberating for weeks or months. No 100-page opinion. Just done.
It clears the docket. It is efficiency in its purest form.
It is. And for a court as busy as the Federal Circuit, which deals with thousands of incredibly complex patent and personnel cases, these Rule 42B dismissals are absolutely vital.
They're the pressure release valves of the system.
That's exactly what they are.
Now, whenever there is a lawsuit, there's money involved. Lawyers, filing fees, printing costs for briefs. It all adds up.
Oh, it does.
The order has a specific line about this. It's the second point. 2, each side shall bear their own costs.
A very standard, but very, very important clause.
What does that tell us about the nature of this agreement?
It tells us that this was likely a compromise, a walk away on the issue of costs. In litigation, usually the winner might seek to have their costs covered by the loser.
Sure.
In the U.S. system, we have what's called the American rule, where everyone generally pays their own way, win or lose, but there are major exceptions. And for this area of law, there's a huge one.
You're talking about the Equal Access to Justice Act, EAJA.
I am. EAJA is huge in veterans law. It's a fee-shifting statute. It says that if a private party, like a veteran, wins in court against the government, and the government's position wasn't substantially justified, the government often has to pay the veteran's legal fees.
Which is a huge incentive for lawyers to take these cases.
It's the only way most veterans could afford this level of litigation. It levels the playing field. But here, the order explicitly says each side shall bear their own costs.
So Ms. Hoppe is walking away from those potential fees, at least for the appeal part.
For this specific appeal, yes. By putting that phrase in the order, they are wiping the slate clean regarding the appellate costs. It's part of the deal.
So the government might say, we'll agree to a remand, but you have to agree not to file for EAJA fees for this appeal.
That's a very common term of these settlements. Now, it's also possible that as part of the private settlement agreement, the government agreed to pay some lump sum that covers fees, but they don't want the court to issue a formal order about it.
They want to keep the court out of the accounting books.
Right. They want a clean break. It ensures that once this order is signed, there is no secondary litigation about who owes who for the price of the appeal itself.
It reinforces that idea of finality we were talking about.
It does. It tells the clerk's office, do not expect a motion for attorney fees in a few weeks. Close the file. This matter is concluded.
And we have to mention the official authentication here. We see the name Jarrett B. Perlow.
The court of court. A very important, if often overlooked, figure in the judicial process.
And the visual confirmation, the seal, and the text that says, issued for the court.
That phrase, for the court, is significant. It's not just from the clerk. It means that even though this is a dismissal based on an agreement between the parties, it still requires the imprimatur of the judicial branch to be official.
So you can't just agree to stop. You have to tell the court, and the court has to bless that exit.
Exactly. The court's jurisdiction was invoked when the appeal was filed, and only the court can terminate that jurisdiction.
It transforms a private conversation between lawyers into a public record.
Correct. Jarrett B. Perlow, acting as the clerk under the authority granted by the rules and the judges, provides that official stamp. It transforms a private agreement into a public, legally binding order. It signifies that the jurisdiction of the United States has been engaged and is now officially being disengaged.
So we have a case that went all the way to the second highest court in the land for this issue, and then poof, Rule 42B, parties agreed, costs are handled, case closed.
It sounds anticlimactic, but legally, It's a finely tuned machine working exactly as it's supposed to.
Which brings us to the broader context. We touched on this at the start, but I want to dig deeper into the legal context and significance of this. We saw that header on the document. Note, this order is non-precedential.
Yes, that one little note.
We said it doesn't set a binding rule, but why does the court explicitly flag that? Why is it so necessary to put that label on it?
Because the Federal Circuit is, by its very nature, a precedent-setting body. That's one of its main functions. Its published decisions usually bind all future cases, not just at the Federal Circuit, but at the lower courts and agencies as well.
So if they issue a written opinion saying this statute means X, then every veteran, the VA, the CAVC, they all must follow X forever.
Or at least until Congress changes the law or the Supreme Court says otherwise, which is rare. So the potential impact of any statement from the court is huge.
So if they didn't mark this non-precedential, someone down the line might try to cite it.
Theoretically, yes. Someone might try to say, look, in Hoppe, you dismissed the case when the parties agreed under these circumstances, so you must do it in my case too. But it's more than that. The non-precedential tag is a signal to the entire legal community.
And what's the signal?
The signal is, we, the court, have not reviewed the merits of this case. We have not made a legal ruling. Do not cite this case as a reason why you should win your case. This is just housekeeping for Hoppe and Collins.
It's a case-specific resolution. It's a private matter that's been publicly recorded, but it has no public legal weight.
That's a great way to describe it. It resolves the dispute between these two specific parties, but it leaves the broader legal landscape completely untouched. It preserves the status quo of the law while changing the status quo of the litigants.
And it avoids creating what you might call accidental law.
Precisely. You don't want a simple procedural order, which the judges may not have even personally reviewed, to suddenly become a binding rule that everyone has to follow if the court hasn't thought through all the implications.
Let's talk about the veterans' claims context specifically. You mentioned the David versus Goliath dynamic earlier, the individual versus the state.
Right. The VA system is massive. There is a huge backlog of claims that's been a problem for decades. The Federal Circuit sees a significant volume of these appeals.
And the system is supposed to be proclaimant, right? Non-adversarial at the start.
It is at the agency level, in theory. The VA has a duty to assist the veteran, but by the time you get to the Federal Circuit, it is a fully adversarial process. You have a veterans lawyer on one side and a Department of Justice lawyer on the other. The gloves are off.
So how does a dismissal like Hoppe v. Collins fit into that kind of ecosystem?
It's vital. I can't overstate this. It is absolutely vital. If every single appeal filed at the Federal Circuit required a full briefing schedule, oral argument, and a precedential published opinion,
the system would grind to a halt.
it would be complete gridlock. The judges simply do not have the hours in the day or the staff to write a treatise on every single case that comes to the door.
So mutual agreement dismissals are more than just a pressure release valve.
They're a load-bearing wall of the entire structure. They allow the court to clear its docket of cases where the parties have found a solution themselves, which in turn frees up the court's precious time and resources.
So when we say dismissed, we shouldn't necessarily think failure for the appellant. We should think resolution.
In many, many of these cases, yes. It means the controversy, the actual point of disagreement, has ended by mutual consent. That is often a victory for efficiency and, frankly, for the veteran.
How so?
It saves the taxpayer money, for one. It saves the veteran potentially years of waiting for a written opinion. And it allows the judges to focus their finite energy on the really thorny cases where the parties truly disagree on a novel or complex point of law.
It's interesting to think of justice not always being a gavel banging and a judge reading a verdict from on high.
No.
But sometimes just being two parties signing a piece of paper saying, you know what, we're good.
That is often the most effective and timely form of justice, agreement. And now notice the timing of the mandate again. That immediate issuance.
December 18th, same day as the order.
Usually, the court waits 52 days to issue the mandate. And that's not an arbitrary number. That is the time allowed for a party to file a petition for rehearing or rehearing en banc.
A rehearing by the full court, not just the three-judge panel.
Correct. Or to file a petition for a writ of certiorari to the Supreme Court. It's the are you sure period, the cooling off period.
The last chance period.
Right. But by issuing the mandate immediately, which the parties would have requested in their joint motion, the court is confirming that the parties have waived those rights. They have told the court, we are not going to the Supreme Court. We are not asking for a rehearing. We want this over now.
It underscores the completeness of the agreement.
It's a hard stop. It returns jurisdiction to the lower court or the agency instantly. So if the deal involved a remand, the file can be sent back to the CAVC or the VA the very next morning.
It cuts out almost 2 months of dead time.
Exactly. 2 months where the case is just sitting in limbo. And for a veteran who might have been waiting years already for a decision on their benefits, 2 months is a huge deal.
Absolutely. Time is a resource, and Rule 42B allows them to reclaim it.
It's a powerful tool.
All right, we have unpacked the parties, the mechanism, the financial aspect, and the legal context. We've really looked at the machinery of this dismissal. Now, it is time for our favorite segment.
The 10th chair.
For those new to the show, the Federal Circuit sits in panels, usually of 3 judges. Sometimes, for a major case, they sit en banc, meaning all the active judges. But in this segment, we imagine we are the 10th chair, an independent voice on the bench.
We look at the facts and the law as presented, and we decide. Did the system work here? What is our judgment? We step out of the role of analyst and into the role of, well, a hypothetical adjudicator.
So, sitting in the 10th chair for Hoppe v. Collins regarding this dismissal under Rule 42B, how do we vote? The clerk has brought us the joint motion to dismiss. The parties have signed it. It's on our desk. What do we do?
For me, it's an easy call. I am voting to accept the dismissal. I concur with the procedural outcome, unreservedly.
No dissent here. You aren't tempted to say, no, I want to hear the arguments. There might be an interesting legal issue here.
Not at all. No dissent. And here is my reasoned opinion why. It really comes down to 3 fundamental principles for me: autonomy, economy, and finality.
Okay, let's break those down. Let's start with autonomy.
The autonomy of the parties. The court system at its core exists to resolve disputes that people can't resolve on their own. But the dispute itself, it belongs to the parties. It belongs to Ms. Hoppe and Secretary Collins.
It's their fight.
It is their fight. And if they have so agreed to end that dispute, the court's role essentially evaporates. Our primary job is done. We must respect the litigants' right to control their own destiny.
So it's not the court's job to keep a fight going that the fighters themselves have decided to finish.
Exactly. The court is a referee, not a combatant. If the 2 boxers step out of the ring and shake hands, the referee doesn't ring the bell for another round. If we were to reject the dismissal and force them to brief the case and argue it,
we'd be stepping over a line.
A big one. We would be acting paternalistically, assuming we know what's better for them than they do. If they say they are satisfied with their negotiated outcome, we must accept that. It's fundamental to our adversarial system.
That makes a lot of sense. It respects the agency of the veteran to decide what is best for her case in consultation with her counsel.
Precisely.
Okay, second point, judicial economy.
We touched on this, but from the perspective of the 10th chair, looking at the entire docket, the hundreds or thousands of other cases waiting for our attention, this is absolutely critical.
Right.
Utilizing Rule 42B preserves judicial resources. The Federal Circuit has a finite amount of bandwidth: judge time, law clerk time, staff time. Every hour we spend writing an opinion on a case that the parties have already settled is an hour taken away from a complex patent case.
Or a trade dispute that desperately needs clarification for an entire industry.
Or, and this is the most important part, it's an hour taken away from another veteran's case down the hall where the government is refusing to settle and a real legal dispute needs to be resolved.
So it's a triage decision.
It is responsible judicial administration. We clear the decks of the resolved cases so we can focus our full attention on the unresolved ones. Anything else would be a dereliction of our duty to the public and the other litigants.
Okay. And finally, finality.
This is where that date, December 18th, 2025, comes back in. The mandate issued the same day.
The immediate effect we talked about.
As a judge in the 10th chair, that's something I would want to provide. By granting the dismissal and issuing the mandate immediately, as requested, we provide instant closure. The waiting is over.
It eliminates that zombie case phenomenon where a case is technically still open on the docket, but nothing is happening.
Right. It's just sitting there during the 52-day mandate period. Here, we can put a hard date on the end of the conflict. And in the legal world, and especially for individuals waiting on life-changing benefits, certainty is a precious commodity.
So by voting to accept the dismissal, we are gifting that certainty to the parties.
We are. We're telling them this chapter is closed, you can move on. That has immense value.
So from the 10th chair, what is the projected impact of our ruling if we look forward from this decision to accept the dismissal?
Well, this specific ruling, of course, has no impact on future precedent. We made sure to mark it non-precedential after all.
Right.
But viewing it systemically from the 10th chair, affirming this outcome every time it's appropriate, reinforces the validity and the utility of Rule 42B as a tool for dispute resolution in Veterans Affairs appeals.
It sends a signal to the lawyers.
It sends a very clear signal to the bar, to the lawyers representing veterans and the lawyers at the DOJ, that if they can get together and reach a reasonable agreement, the court will honor it quickly and efficiently.
It encourages settlement.
It absolutely encourages settlement. It encourages the government attorneys to take a hard, honest look for errors early in the process and fix them before a court ruling forces their hand, knowing they can get a quick dismissal if they do. It lubricates the gears of the entire system.
A solid, well-reasoned ruling from the 10th chair, it really seems like the only logical choice.
In a case like this, I believe so. It is the system working exactly as intended, quietly, efficiently, and with respect for the parties involved.
So, to recap the reality of the situation, not the hypothetical, Hoppe v. Collins is officially dismissed.
By agreement of the parties, under the authority of Rule 42B.
And the cost breakdown.
Each side pays their own way. No winners, no losers declared by the court, just a resolution.
And that brings us to the end of this deep dive. We have taken a single-page order, something most people would scroll past without a second thought, and we found the entire mechanism of appellate justice humming away inside it.
It is always there if you know where to look. The small cases often tell you more about how the system really works than the big blockbusters.
I think you're right. But before we go, we have to give our standard disclaimer. This is important.
Always important. Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice.
And it certainly does not represent the actual holding or views of the Federal Circuit or any of its judges.
We are just two people fascinated by the law, talking into microphones. We're analyzing the public record. We are not giving you counsel.
Please do not cite us in your court filings.
Please, your judge will not be impressed.
No, they will not. But do let us know what you think. Is the efficiency of Rule 42B a feature or a bug in the system? Does the speed of these dismissals surprise you, or does it seem like common sense?
It's always worth considering how these invisible cases, the thousands of procedural orders that don't make the headlines, truly shape the landscape of our legal system. They're the foundation everything else is built on.
That's a great thought to end on. Until next time, keep reading the fine print.
And keep watching the docket.
Talk you soon.